Grace and peace, everybody. You saw the thumbnail, you saw the title. We are, and I want to thank y'all so much for tuning in.
Okay, this is why we have guardrails on trials. The state just leaned over to talk to each other about who this could possibly be. They don't know how to say his name. They think it could be this person, and then they confidently declare he's an unindicted co-conspirator. They don't even know his name.
That is a good point.
This gentleman, whomever it is that Mr. Garlington is talking about, we've never received a list of unindicted co-conspirators, and it's just
okay. I suspect that's because if they knew their identity, they would be indicted co-conspirators. Do you know
no,
I know that there are some who they know the identity of, but do you know the identity of this person?
Not with certainty. That's just what, when we asked the question, like, who do you think that this is? Investigator Vivarito said, I believe that is, and she gave us a name.
Okay.
What did he say?
But there was not a further investigation on the recipient or the
Oh,
calls
then it shouldn't be
that were
letting.
captured in
I think
calls.
these are
It's the context
blah,
of
blah.
the calls themselves that allow us to designate the nature of the call.
Okay.
well, okay. So that
I can't even laugh
that
at well.
call, I don't know how anyone could determine that someone's an unindicted co-conspirator from the nature of that call. They're talking about past events. They're talking about gentlemen. It appears they're talking about gentlemen who were murdered earlier in that day. They're talking about past events. There's no, as
We
far
don't
as
know
I
who
can
they're
tell, there's
talking
no
about, who they are.
planning. To the extent that they're saying, oh, well, it's co-conspirators keeping themselves apprised. I don't know how they can make that statement with such confidence without
One of
even
my favorite movies.
knowing who the person is. And I'm aware, Your Honor, that the case law, that the declarant needs to be a co-conspirator, not necessarily the receiver. However, if you're going to make the argument it's to
That
keep
would be garbage.
gang members or associates apprised, then yes, I believe that the receiver also needs to be part of the conspiracy. So I don't see how this furthers the conspiracy in any way. There doesn't seem to be a conspiracy. And I'll say one other thing that is going to be a common thread throughout these arguments. The alleged facts,
Steele's leaving in a little
alleged
bit.
facts of the Shamal Drinks murder. There's video camera, and there's video camera that puts my client and a car that he's in, and allegedly Demikian Garlington's in that car, although he's never seen on any sort of video. That's the state's allegation. In a separate car is what appears to be Mr. Nichols and Mr. Farley in a car, and I think they're alleging Mr. Boyer is also in that car. They're on video at the gas station. By happenstance, Mr. Drinks pulls up to that gas station after they're already there. Now, let me be very clear. Mr. Stillwell did not commit this crime. However, I will say that Mr. Drinks was shot within minutes of him showing up at the gas station where these gentlemen already were. So by even the state's theory, there's
Why
no
would you say that?
conspiracy
Why would you even
to
say
kill
that?
Mr. Drinks. It's sheer happenstance. And by the state's theory, which we are saying is not true, the decision to kill Mr. Drinks would have occurred within minutes of the death.
Okay.
So
well,
there's not, so it's all based on happenstance, a chance encounter according to the state's theory. There's no grand conspiracy here.
the two aren't mutually exclusive in that there could be a conspiracy to kill people whenever you happen upon them. So,
Okay, and
you can make that argument, but they can certainly make the counter argument.
Okay, and in that case, if that is a conspiracy to kill people, and again, we're just kind of assuming that there's no evidence of that, but nothing in this call furthers any such conspiracy.
Well, honestly, it would have helped to have known what you said after the call, before the call, so that I know what I'm listening for. So I'm going to need to listen to the call again. Okay. And then let's do it the other way for the remaining calls. All right. All right. Both of the speakers seem very familiar with who the people are, and it may not be I'll give you, they don't seem to be plotting any retaliation in this call, but they do seem to be getting apprised of what's going on. And it'd be an all-out war and things like that. So I'm going to permit that under the co-conspirator exception.
Flag on each and every one of y'all.
Can I, Judge, on behalf of Mr. Nichols, I'm going to join in to
Of
each
course
of these.
you
and I
are.
may
Of
have something
course you
additional.
are.
I do want to
You're
say that
kidding me
for
right
all
now.
of these, I don't know whether the state has established that there was a conspiracy that existed, which is
We don't
the
even know who
first
these people
element
are.
of any admission of 801D2E purported statements. And I think what I heard in this, although a lot more was played than was in the spreadsheet, and I understand that may have just been a mistake, but I heard a lot of "I think" and "who is that?" And it sounds like I got that on Instagram. So I want to have a continuing objection, and I'll object again when it's appropriate, to what's commonly referred to as nested hearsay, which is somebody saying what somebody else said. It's hearsay nested within hearsay. So I don't know whether, well, I don't agree, of course, with the court's ruling. I'll abide by it, but I think there's more to it than just they're telling them what's going on. I think they're telling them what they heard, what's on Instagram, and I want to make sure that this quay, somebody said quay, not qua, or qua, but quay, and I think the response was, "Who's that?" And then they talked a little bit about that. That is not Mr. Nichols. And if there is any dispute about that, we can go into that further.
All right. Well, with regard to the nested hearsay objection, I don't think that what got posted on Instagram or anything like that that might be nested. It's only hearsay if it's being offered for the truth. And that type is not, I think, being offered the truth. Is that correct, Ms. Love? It's being offered to show that they are trying to keep apprised of the latest that's going down between these rivaling factions.
That is-
So overruled.
How dare you, sir!
And I mean, yeah, it certainly sounds like quay to me. And all right, and so this would be evidence simply of the pattern of racketeering activity by members of the alleged RICO enterprise.
Yes.
Okay.
Your Honor, I'll point out that these are different individuals, different types of drugs,
Mm-hmm.
and from absent the count that the count involving Mr. Williams from 2022, those other examples of drug-related overt acts are from approximately 9 years before this wiretap.
Okay.
And Your Honor, the counts, the substantive counts that you just referred to, they're all on May 9th, 2022. You should know that's the date that Mr. Williams was arrested. He has a home, he has many homes actually in Atlanta and elsewhere. And law enforcement officers found several people who lived at that home. This was not a distribution.
I mean, I understand very clearly that the state's alleging this and the state's proving it as, yeah, I understand. People have drugs. They may be illegal, but people have drugs. People have parties. Sometimes people have a lot of drugs. And establishing that you've got a lot of drugs and establishing that you are intending to distribute those drugs to garner additional money for your alleged enterprise are two entirely different things. That'll be up to the jury to decide. They can offer their proof. I mean, that's not what I'm here to decide. I'm here to decide, is it admissible under the rules of evidence? So I hear what you're saying. You're gonna have to tell that to the jury. That's not up to me. All right, so I understand the purpose for it. So let's go ahead and hear do we know who the female is?
We do not have information.
So Whether it proves it or not is yet to be determined, but I'll permit that under a co-conspirator exception to hearsay.
What?
And for the record, Your Honor, I would also argue not only is this not part of any conspiracy, but also that Mr. Garlington informing someone that Mr. Stillwell is out of pills is not in furtherance of him selling pills.
No, but it might establish that it's something that he typically does.
I understand why the state wants it in to show that my client's a drug dealer, which is why I want it out. But the hook for admissibility is that it's in furtherance of the conspiracy, as I understand the law of co-conspirator statements, and I don't believe it's in the furtherance.
Okay, so I mean, I think it does show that Mr. Garlington is involved in, has knowledge of SB's supply chain and when he has it and when he doesn't, and what has just happened. They've just been bought out. I'm going to permit it. Again, whether that's an ultimately successful and convincing argument is for the jury.
Keep telling yourself that, dog.
You may.
And for the proposition that buyer and seller cannot be co-conspirators, it's Darville, Darville v. State, 289 Georgia 698 at 715. It's a 2011 case.
All right, but it doesn't appear that Mr. Garlington is a buyer or a seller right now. He seems to be kind of a middleman for communication. So if your argument's he's a buyer or a seller and it can't be both the buyer and the seller, that's not who's having a conversation.
No, my argument was that the state's seeking to get in the words of this young lady who is clearly a buyer. And if we're saying that YSL is a set of sellers, a conspiracy of sellers, she cannot be a conspirator with them. And that's my argument.
Okay, well, I'm admitting his statements under the co-conspirator exception, and hers would just be to give context to what on earth he is talking about.
Amazing. Every word of what you just said was wrong.
Mr. Stillwell is apparently on the recording, or what's alleged to be Ms. Stillwell saying, but I couldn't find it. I don't know what the state's theory on how this advances a conspiracy. I can guess, but the pronoun it doesn't make a lot of sense to fit their theory. So from the context, I don't see how that could be in furtherance of a conspiracy. That seems just like talk, which we obviously aren't privy to the conversations that these gentlemen have offline, which would provide context that they have it with each other. But that's my objection.
So, Your Honor, we believe this is a party opponent statement of Mr. Stillwell, but from the state's reading of this call, they're trying to do a drive-by shooting, but they can't find the op, just to put it plainly. And then when they're asking, when one is asking what you're getting into and the other one says the same shit, essentially they are apprising one another of their efforts to shoot an opposition gang member.
And I don't know whether it says it or him, but
Right.
regardless, I mean, the whole context of it, you can tell that's exactly what they're talking about is what Ms. Love just offered. I'm going to admit it both as an admission by a party opponent and under the co-conspirator exception.
Oh! Somebody! Oh! He needs some milk!
Hear from anybody on the defense side?
Same objections, but I heard a lot of nested hearsay in this. There's speculation. There is, I heard it, they heard it.
This was a computer. Hold on. 11 alive.
Within the particular definition of 801D2E. And I just want to say that the courts have said, and I quote, "The proponent of the out-of-court statement is not entitled to a free pass. A judicial determination that a co-conspirator's statement tended to further the conspiracy must be supported by some plausible basis in the record. To that extent, the in furtherance requirement represents a real limitation on the admissibility of co-conspirator statements." Here, half of the conversation is by an unknown declarant. We do not know whether or not that person is part of this alleged conspiracy, or even a non-noticed and never noticed alleged co-conspirator. We asked for a list of co-conspirators in November of 2000 or December of 2023. We've never been provided that. And all of a sudden we get into these hearings and everybody in the world, the guy at the gas station, the guy on the corner, Hillary Clinton, they're unindicted co-conspirators. And
What did he say?
find that out when we're sitting here arguing about it. So this is a distinct example of speculation by an unknown declarant.
I'll add, Your Honor, that, and maybe I'm the only one, but listen to that. I understand that there seems to be general criminality maybe just discussed, but as far as distinct, what they're talking about and distinct crimes, I'm a little lost when I listen to that. So I don't know how, if we don't even really know distinctly what they're talking about, I don't know how we could deem their subject matter part of a distinct conspiracy.
State want to reply?
Yes, Your Honor. I think that the context of this call makes it clear that they are apprising and warning one another of possible harmful actions by an opposition member and keeping one another apprised of possible harm at the hands of opposition is an act that furthers the interest of the conspiracy being the YSL enterprise, the criminal street gang that is YSL, in keeping their members out of harm's way from being harmed. That type of sharing of information furthers their interest in knowing what the opposition is doing and is about to do and may do to them.
All right, I'm going to rule that that's admissible.
That one, there was a violation. Personally, I wouldn't have it.
It's page 71. Demekion Darlington is asking Shannon Stillwell if he should bring the whatchamacallit. We believe that the whatchamacallit is a gun. And bringing the whatchamacallit allows one YSL member to be prepared for the opposition that we believe they anticipate they may be encountering.
The state in their lead-in, are they giving the court and us what they believe this is about, or are they quoting to a previous call that they're saying provides context? Because the state just declared like all of these facts, but I don't know if that's based in fact or just kind of their theory.
Judge, we give the court the reason that we believe that the call is pertinent and the reason that we believe it furthers the conspiracy. If there is an alternative interpretation made by anyone, then obviously that's an argument that they can make. But this is the reason that we're offering and attempting to have this deemed admissible. That's what the court asks us.
Okay, well, I mean, I'll listen to what's on the call. Is there more to that conversation, or that's just all we have?
That's all that there is to that call, but we have other calls during this time, and Ms. Hilton sort of gave the court the timeline, the reason that we believe that this call is referring to a gun. They're not wanting to say gun, and they are obviously arming themselves for what they believe is about to happen as a result of the fact that two of their associates have just been gunned down.
All right.
The state says they're obviously doing this, obviously doing that. And I understand, things are for the jury to determine. But my point, Your Honor, the danger of this is everyone sounds suspect when they're on a wiretap. I mean, that's when you hear a wiretap conversation, it sounds suspect. And the reality is later on in this, we're going to hear some more calls. And Mr. Stillwell talks about bringing things out wrapped in a towel, bringing things out, make sure it's white. And here's the thing. We litigated some things earlier. Mr. Stillwell was arrested in the middle of a sacrifice of a goat.
Say, hold up, wait a minute, something ain't right.
And the backstory behind that is E5 religion and different practices involving that. We suppressed that information. There's in this, and I don't think I should have to argue this to the jury and bring up religion, but the reality is there's multiple references of bringing things in towels. And as part of that religion, there's a thing called elekes, and they're the beads. And they're not to be brought outside unless wrapped in a towel, and preferably a white towel. They're supposed to be wrapped, not exposed to the element or outside. So there are alternative explanations for a lot of these things, and it's just bare speculation by the state. And to refute that, I don't really want to get into my client's religion and all of that. And I guess I will if I have to, but there was a reason that was off limits. And if we're just forcing me to present all that just based on bare suspicion by them and speculation, I don't think that's appropriate. I think we have to demand that they have some actual evidence of this is what they're talking about, and it furthers the conspiracy, not, oh, we think this is what they could be talking about. And that's my concern.
Okay. And it seems to me that the timeline that they provided is enough of the evidence to suffice. It's not in a vacuum. I'm going to admit this over objection. Let's move on to the next one.
Emotional damage.
Hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.